Good afternoon, everyone. My name's Tom Williams. I'm a partner here in the Louisville office of Stolkeen and Ogden. Next to me, I have Michael Tierney, and I'll give him a more complete introduction later. Welcome today to this ever timely topic of crisis communications. Many of you are in-house counsel, and this is something that may come across your desk late at night. Here's our contact information, and we'll have this at the end of the presentation. And just so you know, this session will be recorded, edited, and posted to our SKO YouTube channel. When we get to the questions at the end, we'll turn off the recording so you can feel comfortable to ask whatever questions you may want to ask. Following the webinar, you'll be sent an email from Renee Lamb with the Indiana and Kentucky activity numbers to claim CLE credit. And if you have an opportunity, please complete the short survey monkey in the email. So here's our setup. Your phone rings late at night, and I'm assuming you may be the general counsel, or you may be a business owner or somebody intimately involved in business. And normally you wouldn't take that call, but you answer it, and you find out that your employee, while he's proudly wearing his company uniform, slugged a peaceful protester. It's all over the evening news, and in this case, if your CEO calls, he wants answers. His phone's ringing off the hook. Now what? What do you do? Well, I started practicing law 31 years ago, and we didn't even have voicemail when I started practicing. So the things that happen in technology now are absolutely amazing. And the common advice to any lawyer was, well, this could go to litigation, no comment. But we're in a completely different world now. We're in a world of social media. We're in a world of 24/7 news. We're in a world where, as Warren Buffett says, it can take 20 years to build a reputation and 5 years to destroy it. So I think the old answers aren't what you might want to do today. You're going to want to do something more sophisticated to be able to get your message out in a clear and concise manner. This example we have here is in a kind of an exploding type of situation. There's also the unfolding types of situations where your organization's involved in potentially high-profile litigation, particular filing, it becomes a new story, and you've got a broader audience to deal with than just the judge in front of you or the jury. You've got an audience of your peers, you've got an audience of your customers, and you want to make sure things are done the right way. So back to the question, what do you do? What's next? But before we get to that, I want to take a step back. I often take opportunities like this to justify my degree in philosophy that I got. My parents were not pleased with that decision, but we like to ask the question, I've always liked to ask the question, why was Socrates the wisest man? What is a wise thing to do in this situation if you're faced with this emerging crisis and the need to respond quickly? If anybody wants to put in the chat box why Socrates was the we might give a few golf balls for a correct answer. But we won't wait for the chat box. We'll move on. Socrates was considered a wise man because he knew that he didn't know anything. And I would venture to guess that maybe not with all of you, but with many of you, the same will be true about you in public relations. So when you're faced with a crisis, an internal crisis that could become a public relations crisis, my strong advice to you is to get help. You want to maintain the reputation and integrity of your business and have some control over your message. So if you don't want to take my advice, I'll go ahead and tell a story on myself. A few years into my practice of law, maybe in the mid 90s, I was representing nonprofit organization that was made up of a volunteer board of directors. It was a local nonprofit. I won't tell you who it was, but they were ending up on the evening news on particular issues back when actually the evening news was the thing that people watched. And none of them were comfortable with being in front of the cameras. They were nervous. They didn't necessarily know what to say. And so they asked me to step in as their front man. And I, being young and naive, I gladly accepted the assignment. I wrote bullet points. And, I took the call, and I still remember who the call was from. It was Mark Hebert. A lot of you may remember him. He's a local news person and has been, worked in public relations in various larger organizations around town. And Mark absolutely ran me up and down and taught me the lesson that the next time I get an opportunity like this, I was going to bring in professional help. And in doing a diagnosis of that situation, I think if I had to do it over again, I would have asked the question, is an outside lawyer the right person to speak on behalf of this issue? I mean, maybe I would have been the right person to speak, but maybe not. And what I see now was that I didn't understand the way the media operated. I didn't understand how to effectively get our client's message out, and that I needed help. So that's why we're here today. I'm mostly the setup man for my partner in crime here, Michael Tierney. Michael and I have worked together on a whole host of crisis communication situations. Michael has a long and distinguished career in corporate America, but he's been the chief operating officer of Tandem Public Relations. I've worked with Michael in a lot of very sophisticated, sensitive situations, and he always shows creative and thoughtful responses to challenging situations. He's, if you're a lawyer, you're not trained necessarily to put things in the simplest terms and the easiest way for people to understand. But Michael is very skilled at that, and we've worked on situations that were quickly evolving to situations where really the goal was to not have news coverage. And Michael is an expert in this. I was going to call him the Socrates of public relations, but that would mean, under my definition, that he doesn't know anything. And actually, Michael knows quite a bit about what we're talking about. So with that, I'll turn over this next phase to Michael Tierney.
So I always like to tell the people that I work with that the trying to balance your legal risk and your reputational risk is absolutely not a binary choice. I'll tell you the best definition that I've ever heard was written by a lawyer in Philadelphia who also was trained and worked for a short time in the field of public relations, and probably one of the best that I've ever seen at understanding sort of the duality versus the binary nature of a crisis situation. The way that she described it was that lawyers advise and counsel on the legal implications of decisions and actions. Right? That's pretty cut and dry. That's clear. That's protecting your space to make sure that if your issue ends up in a court of law, that you have the flexibility to execute in the strongest and best possible way for your client, right? Whereas PR professionals advise and counsel on the public implications of the decisions and actions. There are a lot of situations where one of two things is true, right? You can win in the court of law and absolutely tank in the court of public opinion. And the opposite is true as well. The goal here is to sort of give you a little bit of information about why it's critical to strike that balance of the sort of managing your legal implications and your public implications simultaneously and oftentimes on equal footing. So I just wanted to be super honest and upfront about the situations that I most encounter. Right? Tom alluded to the fact that I've spent a number of years of my career in corporate. There seems to be an of counsel hierarchy, right? Whereby your legal counsel in most of these situations has the ear of the client and the final say on what direction you take when you are in a crisis. I understand that pragmatically, right? In the business world that's populated with negotiations, contracts, and other legal documents to rule what happens, lawyers are a must-have, not a nice-to-have. Right? So often, communications or a public relations professional is not in that mix. Now, the opposite is true in corporations, where I spent the majority of my time. In corporations, your legal counsel and your public relations counsel both live in the same C-suite, right? Their voices have equal import, and CEOs of large corporations understand that delicate and important balance between the court of public opinion and the court of law. It's understandable, right? In a market like Louisville that is largely populated by small and medium-sized businesses, that this situation arises. But I think if I leave you with anything today, I hope that you'll remember the best practice that there is a case to be made to ensure that you're protecting sort of both sides of that equation at once. Now, the first place that lawyers and PR people get sideways is by not understanding one super simple thing. Your primary audiences are completely different, right? Tom's audience is the judge and or the jury. He's very megalomaniacally focused on ensuring that he's protecting his legal position and that his audience, is most powerfully moved by the argument that he makes. I, on the other hand, approach the situation representing everybody outside that courthouse, right? The customers, the employees, the suppliers, the stockholders, the community leaders. And particularly now in the day and age of social media, where anybody with a keyboard fancies themselves either an opinion leader or worse, a publisher, that part of the equation becomes super duper important. I always approach everything with the hallmark that message discipline is the most important component to what you do, right? And by what I mean by message discipline is that most people, and I'll go back to Tom's example of his ill-fated foray into public relations, and I'll answer your question for you. By the way, you were not the right person to do that interview. It's all about message discipline, and what message discipline is in a nutshell is telling stories versus answering questions. I don't imagine it's completely dissimilar to witness preparation. I know you would likely not put one of your witnesses on the stand without knowing exactly what part of the narrative that they're going to populate, the story that they're going to tell, and how it really affects your overall strategy. The same is true with how we select and train our spokespeople to speak on behalf of organizations, particularly in a time of crisis. And there are some very specific goals that you want them to accomplish. But first, they need to know what customers and employees care about. Right? Your narrative should be built wholly around what your public perception is, protecting your reputation, and continuing to build and support that relationship between you and your customers. One of the other primary goals is to fill in the blanks and foster empathy and understanding. Very few stories are two-dimensional, right? There's a right side and a wrong side. Stories are complicated, messy, and often sort of opposing perspectives on a set of facts. Our goal is to make sure that we tease out that complexity and deliver our narrative in a very approachable, understandable, and when you're really winning, common sense perspective. Because when you get people at home watching or reading your version of the story, and heads start to nod, because even in the most complicated of situations, if you've been able to explain to them what it means in lay terms, explain to them the actions that you took or didn't take and why that is important to them, you know that you're beginning to win. So this is what I've found to be the hallmarks for successful legal and PR relationships. It largely comes out of my time at corporate, but I can honestly say that working with Tom on a number of situations that have arisen with clients of his, we follow this to the T, and it all begins with early collaboration. When I'm working with one of Tom's clients through Tom, right, I consider us to be a team. I'm an extension of his team. So the first thing that we do is sit down and have sort of that full disclosure moment where we identify all of the strengths and weaknesses and opportunities in what it is that we need to project on behalf of the client, right? Now, in some cases, Tom will want to be protective of a particular legal strategy, right? And I will want to really advocate for a particular public-facing strategy. The goal is to identify the shared objectives and start there, because there always is a vein of shared objectives in terms of client protection, reputation protection. The third sort of critical piece to working successfully together is establishing your roles and responsibilities, right? When Tom brings me in, I know that he's the team leader, right? Conversely, when Tom brings me in, he knows that there is a valuable perspective that our voice at the table brings in the protection of his client. But understanding who is in charge and what your deliverable expectations are is critically important, right? The fourth thing is consistent and ongoing team communications. And I can say in all honesty that it generally tends to be, a 5-minute catch up here or a 15-minute strategy session there, so that I'm well aware of what Tom is doing on behalf of the client, and he's well aware of how the situation may be shifting on the ground based on either the most recent coverage or the weighing in of an opinion leader or group that has a particular amount of sway with the community, right? And finally, if you find yourself at an impasse, and fortunately, I don't think we ever have, but sometimes you do, right? The tiebreaker is the client. Right? That all of your mutual counsel should be client centric and weigh the risks versus rewards of either part of that equation, giving up something to ultimately to the end for the client.
Yeah, and I think I would add to what Michael said, that really the client is in charge of these types of communications. It's their business. Different clients have different appetites for various types of risk. Different clients have more concerns around legal issues, or they may have greater concerns around public relations issues. And so when Michael and I are working together, we're listening very closely to the client and what the client wants to accomplish with the situation in front of them. I reference here that the legal issue associated with working with a PR expert is protecting the attorney-client privilege. What I found in working with Michael over the years is that, if he's connected with a firm like Stolkien and Ogden, we're going to have a subject matter expert for whatever crisis is in front of us. If it's a product liability issue, if it's an employment issue, if it's maybe even potentially some kind of white collar criminal issue, Michael will take the charge of simplifying the message, making sure that it works effectively in media outlets and channels, really in kind of guiding the bigger part of the process, where the Stolkinen lawyer will work in terms of risk avoidance, identifying risks, helping the client assess what they need to do next vis-a-vis the legal framework. But when you're looking at protecting the attorney-client privilege, maybe the factors to consider is who is making the engagement. What I've seen from the cases is that if you have an outside counsel engage a public relations expert in the midst of a crisis, that's a very strong scenario for strong protection of the attorney-client privilege. That's especially true if the public relations expert is serving as a company representative, which is what they would be doing if they're engaged by the outside law firm. And of course, it's all in terms of seeking legal advice from corporate or outside counsel to guide the work.
And there's never an email that goes back and forth between me and the client that Tom is not copied on for that very reason.
Yeah, and the question often comes up is, how do you protect your relationship with your public relations consultant? And our simple solution to that is just to have a very clear engagement letter, that can either come from me or it can come from the in-house counsel. We don't recommend that you would have an engagement letter with somebody who's a non-lawyer. I think it just really runs a lot of needless risks associated with losing the attorney-client privilege if you set up the engagement with someone other than an attorney. When does your public relations consultant become a witness? When you might lose your job if you're in-house counsel because you waived the privilege. And next month, SKO will be putting on a seminar with a deeper dive into attorney-client privilege. But, maintaining the privilege so these sorts of communications are protected are critical. There's been a high-profile situation in Louisville involving a major CEO where there was a leak with a public relations consultant. So if you're general counsel or you're outside counsel on an assignment like this, it's incumbent upon you to make sure that only the right people are involved in the communications, and essentially that there's no waivers of privilege. The reality, I talked before about kind of exploding crisis and then unfolding types of crises. In preparing for this session today, one of the commentators said that in today's environment, almost every crisis becomes litigation. There's going to be somebody who is going to file a lawsuit. And I think, a really very simple tip that is often not followed is, be careful what you say in pleadings. Anything that you file on behalf of a corporation is public record if it's filed in a court proceeding. And the media can pick that up and read it. The very strong example that I can give of that is a situation where the Tracy Morgan, a 30 rock star, was rear-ended while he was riding in a limousine a few years ago, and it involved Walmart. And what would be considered just standard rote responses in an answer to the complaint became major news. Walmart, through their attorney, alleged that Morgan failed to properly wear an appropriate seatbelt restraint device over the accident. And in this accident, he was severely injured, and I think one of his friends was killed. And Morgan, made a public statement, and the headline was, "Tracy Morgan can't believe Walmart blames him for his injuries." And to Michael's point,
that's just good PR.
Yeah, that's how something very small and simple said in a court pleading can get translated into a really negative headline where very few people would probably bother to read past the headline. And I've not been involved so much in working with Michael, but I could foresee this, for special types of litigation, if you have a high profile plaintiff or participant, or litigation that's being followed closely in the news, you'd want to scrub your pleadings to make sure they are easily digestible by the media, and you might want to engage someone like Michael to help with the messaging, to make sure that you don't win in a court of law but lose in the court of public opinion, to Michael's earlier point.
I want to underline and put an exclamation point under your point about pleadings, because a very, very common way for the news media in every market, but particularly in this market, to dig up stories, right, and find out exactly what's breaking in. They assign people to the courthouse, and their job every day is to go through filings, right? I would tell you that probably 70% of the problems that my clients or shared clients have encountered have come from the folks who sit down at the courthouse and review filings on a daily basis.
So we'll circle back. We're following Michael's advice on telling stories. So what happened with our employee who hit the protester? The hypothetical was actually built on a slightly different scenario that arose last summer. In that particular scenario, an employee brandished a gun at a protester, and it hit the news. And the client was faced with kind of picking which side of a major cultural battle that they would end up on. Michael and I worked together hand in glove on that situation, and we applied the client's values to the situation, and they made a decision. Michael, got ahead of the issue in contacting the local news media outlets with the client's story, and as this unfolded, the client had to pick a side of the issue. It was either going to be on the gun rights side or the protester side. They picked the side they needed to pick, and they kind of geared and braced themselves for the fallout that was going to come from the other side. And so part of the messaging was prepping and training internal personnel to handle the calls appropriately, and basically a triage of if and when new messages should come out. So again, each one of these situations will be different. We're pleased to report that, that situation blew over. It didn't ultimately result in any kind of litigation, and it was old news much quicker, I think because of Michael's assistance in that situation. And that was one of these situations that bubbled up over a weekend. So it was a weekend phone call, and we were prepared by Monday morning to have a conversation with how to move forward. So before we get into some other real life scenarios, in order to get CLE credit, we need to do a poll. And this poll won't make sense now, but it will make sense later. So I think, yeah, there we go. So hopefully you've answered the poll. And I'm going to go ahead and close the poll and turn it back over to Michael to just talk about some other real life scenarios.
So I'm just going to dial through a couple of examples of what I think are some of the more interesting crisis situations that I've been charged with managing over the years. they're all very different. So hopefully, at least one of them will resonate with you in some way or another. I'm going to start locally, and we have a client who touches, a million plus people a year in this community, very high profile, that found themselves in a situation with an employee who was requesting to be transferred / promoted within the organization. This was an individual who already had an established track record of not being particularly, not a particularly strong attendance record. So there were a lot of reservations. And ultimately the decision was made that promotion and that move was not appropriate at the time. At that point, the employee stopped coming to work, right? 3 months passed, and the head of the organization received a letter that asking from the employee if they had made a decision, if they had reconsidered their decision about the employee, with a follow-up that said, because if you don't, we will be forced to file a suit against you, that this decision was made based on race. The employee in question happened to be a Black woman. And any threat of racial discrimination, particularly in this sort of flashpoint moment that we're in, has to be taken incredibly seriously. So we got on the phone with the head of the organization, their counsel, and we pointed out that this really needed to be addressed head on. Should this former employee follow through on their threat? We needed to establish that that DE&I is a cornerstone of what the organization stands for. It's reflected in the numbers, both the people that we serve in the community and the people that are employed within the organization, and that it probably was in our best interest to start working that day to compile that information to be prepared to respond should the suit be filed. The counsel on the other side was adamant that that not be the case. That and that as a point of evidence that this is not a racially motivated decision, we contend that the employee abandoned their job. Okay, so up until that point, I guess the lawyer was on board. But when we stated that it was critically important that we sort of punctuate the story with the fact that the employee abandoned their job, the lawyer disagreed. In order to protect their ability to defend this job abandonment case, which, I'm no legal scholar, but I think that it's fairly cut and dry. They did not want us to mention that factor at all, which in the scenario of public opinion, if you're not giving the reason, then you're giving air to the reason that that the people on the other side are advocating for. Fortunately, it did not go to litigation. They never filed the grievance. Eventually, I think the employee went on to do something else. But I think it's a super good example of how you have folks who are trying to protect the legal side of the equation and folks who are trying to protect the public side of the equation, who maybe don't understand that they're both two sides of the same coin, and a client who's prescribing to this sort of arcane hierarchy of representation where obviously the lawyer wins, right? I think it's a fairly safe and benign example because nothing was filed, but I hope it punctuates the fact that there are still folks who absolutely do not consider the implications on both sides. I'm going to flip for a minute to back in the 90s when I worked for a company called MCI. Anybody on this call old enough to remember when selecting your long distance carrier was high tech and sexy? You're my people. Anyway, we made our money at MCI by basically selling air, right? It was essentially selling long distance time by billing it 50 different ways. And one of our most successful products, and honestly, a product that really was very disruptive at the time. We're in a world now where the only time you get a collect phone call is if you are in the unfortunate position of having someone call you from jail. But back in the day, it was fairly common for people to make collect phone calls and reverse the charges to the person receiving the call. At that point, you really only had one choice. When you picked up the phone and you dialed 0 and the number of the person that you were trying to reach, you got charged whatever rate that particular segment of the Bell family charged for that service. At MCI, we came up with a product called 1-800-COLLECT. And it was really kind of game-changing at the time. Because for people who couldn't afford phone cards with prepaid minutes, who maybe didn't have any established credit or a phone line of their own, who legitimately had no other opportunity to call the people that they needed to reach was by collect phone call, we offered them a way to do that could dial around the bells and guaranteed them a lower rate than any of the bells charged. It took off like wildfire. It was one of our most profitable products. It had an amazing advertising and marketing campaign behind it that really made it sort of very, very widely followed and appreciated. About 6 years into that ride, we found out through the media that one of the users of the product had made an interesting discovery. When placing their collect call, they found that they started being billed for time at the time they placed the call versus the promise that was made, which was, we're going to start billing you when the other person picks up. Right? There was no malice. There was no ill intent. It was a programming error that had existed for years that nobody had figured out until the day that this customer found that they were being overcharged. Without going into too great a detail about how something like that might happen and how you figure it out, let me tell you what happened that day. The Associated Press moved a story about this person being overcharged. They did some back of the envelope math based on our public filings of the profitability of that product and called it a $1.7 million overcharge. Because nobody approached us ahead of time, we were not prepared for this. We had to catch up very, very quickly from the time we read this story at 10 o'clock in the morning till the time we started to respond at 11:30 that morning. At which point it was already starting to sort of gain a little bit of traction across the media landscape. The first thing that we did was to apologize because it was an engineering error on our part. And, if we were going to maintain any kind of relationship with the clients that had grown to trust us, we had to own that mistake and we had to apologize for that problem. It's another area where PR people and lawyers often come to blows because in lawyer world, making an apology is an admittance of guilt. I contest that is not necessarily the case because as you start to parse out what happens, it may or may not be anything other than an apology to the people that you serve and the people that you trust. But anyway, it's a hallmark and good practice in public relations. So it's the first thing that we did. We apologized for the error. But the second thing that we did was redimensionalize the problem. If you remember, I said that the Associated Press reported that it was a $1.7 million overbill. Right? Well, if I'm a user of 1-800-COLLECT, I'm thinking, wow, they overcharged me a lot of money. Right? So I quickly had my engineers and my accounting folks do a quick accounting of what that meant, what percentage of calls could potentially have been affected. and divide that across our user base and figure out what's the implication, even to a heavy user of the product, right? Somebody who uses it, between 5 and 10 times a week. And it turned out that the problem was a 6 cent per customer per call potential overage. 6 cents is very different than $1.7 million, right? In any way you slice it. So I immediately got on the horn with the Associated Press, explained the error, had my engineers explain the error, talked about the small subset of people that were probably impacted, and punctuated it with a counter to their $1.7 million overage claim by explaining that, this was a potential 6 cent per customer problem for customers who were affected. And again, everybody wasn't affected. So rather than wait for the litigation to come, and rather than wait for somebody to come after us, we went and did full disclosure, right, with the powers that be at the Communications Commission. And we said, here's a problem. We own the problem. We want to own the solution. It's a 6 cent overage to affected users. Our heaviest user uses us, 10 times a week. We propose giving anybody who wants a 75-cent refund. No questions asked. Have to sort of prove the calls that you made. If you file with us, if you call our hotline that we immediately erected and say that you are a 1-800-COLLECT user, we will send you a check for 75 cents. Now, what that did immediately was make whole the people who used us the most, right? But what it really did was limit our liability, both in the court of public opinion, but also in the courts, right? Because we came up with a proactive solution to solving this scenario that ultimately resulted in the $1.7 million problem being reframed as a 6 cent problem. And ultimately, the company only paid out $16,000. So all in all, it was a big win all the way around. Now, some cases you have a mandated response, right? So for example, fast food toys are overseen by a federal regulatory body. And if you ever find yourself in a situation where there is bodily harm caused by a trinket that you distribute with a children's meal, or even worse, if you have a foodborne illness situation also regulated by the feds, they are very clear on the fact that the best practice is having your legal team and your public relations team work together. So much so that they'll mandate, in the case of this particular incident, we had a fast food toy that choked a child. And the way that they mandate that you follow up on that with the public is you immediately, on the legal side, you conduct a recall. On the public relations side, you have to show due diligence of trying to reach as many people as possible who could come into contact with the product. It's not a particularly sexy example, but I think it's an important example that shows that even the regulatory folks who are not necessarily known to be forward-thinking understand the need for the two parties to work together, that the legal side of the equation and the public side of the equation are handled sort of in tandem. So the last example that I'll give you, and I hope this will shine some light onto why Tom created the survey that he did, is the story of KFC and the Franken chicken. So back in the late 90s, early 2000s, it was the early days of the internet. Media was not really a thing, but early adopters learned really quickly that the internet is a great breeding ground for conspiracy theories. And the one taken up in this particular instance was trying to answer the question, why did KFC shorten their name from Kentucky Fried Chicken? And the conspiracy theory that took hold was that we were not allowed to use the word chicken in anything that we did because what we served was not, in fact, chicken. It was this hybrid Franken animal with six legs and no beak that we expressly sort of mutated so that we could get enough chicken legs to fill our buckets. Having been to more chicken plants than I would like to admit in my 10 years at KFC and understanding very well what our procurement and distribution looks like, and being a person with common sense, I can tell you that is not the case, right? There were no Franken chickens, and the number of people who were super interested in both kind of reading about and disseminating information to the contrary needed to be dealt with. So rather than deal one-on-one with people calling in and the occasional flurry of media calls that we would get, we decided to make a more proactive stance. And that was to find a single outlet that reached the broadest number of people who were most likely to spread this rumor. And it was tended to be sort of spread by young people, 15 to 25, who were early adopters of technology and flooding the internet with this Franken chicken rumor. So I went to a show called Urban Myths and Legends on MTV. So the answer was really super simple, right? There's still a little bit of an argument internally about why it was done, but essentially, when KFC felt like it was old-fashioned, they felt like they needed a new brand positioning, and they made the decision to go from Kentucky Fried Chicken to KFC because shorthand was what everybody was doing, right? In a world of sort of longer, more complex names, you know, your video cassette recorder was your VCR, right? And the place where you get your Kentucky Fried Chicken was KFC. And so the explanation was really that simple. And what that did for us was it talked to the people who were most likely to spread the rumor in a venue that they watched and trusted, and to people who might hear the rumor outside, who are not MTV viewers and had no interest in sort of the Urban Myths program on MTV. It gave us a legitimized national outlet that we could share with any media organization that approached us going forward, and it resulted in, rather than doing awkward telephone interviews on a one-off basis, we would just shoot them the tape from MTV. MTV was thrilled because they had to be noted that the tape came from them. So they were more than happy to give us the rights to distribute it. It worked super well for us because we had a live person to kind of explain, dismiss, and put into clear, logical, common sense context why the decision was made. And it became a really quick, easy, inexpensive way for us to respond to any questions about it, and very, very quickly sort of shut that one down.
Thank you, Michael. The audience can see why I enjoy working with Michael so much. He's really come up with a lot of very creative solutions to challenging situations. We're going to open it up to questions in the chat box, and I'd like to kick off a question because I know a lot of people, in our audience are going to wonder, how often do you serve as a spokesperson for a business? And if you're not the spokesperson, how do you train and prepare someone to be a spokesperson on a crisis communication If you and I know each situation is different, but what's your thought process in that?
Well, generally, every organization has a face, right? And I'm a really strong advocate for having the face of the organization be the face of the crisis. Generally, in the case of smaller nonprofits, it's the executive director. For companies, it's generally the CEO. The exception to that would be if it is a very specific operation problem that you're responding to. You can have your chief operating officer or somebody who oversees that part of the business. I'm not a big fan of outside counsel or even your internal counsel being your spokesperson, because the only time you see them, unless you use Tom Williams as your spokesperson for everything you do, right? If you're, say, just name somebody arbitrarily, right? If you're Salvation Army and every time you kick off your kettle drive, it's Tom Williams that you use to talk about the kickoff of the kettle drive, he's probably not the person that you want in a crisis situation. There is a familiarity generally with at least your near-end stakeholders. They're used to dealing with the head of the organization, that know them, that trust them. And I'm always an advocate of taking the time to arm them with the tools that they need to be successful, which are the right talking points, which is a clear understanding that they are there to tell a story, not to answer questions, and a little bit of simulation and role playing to prepare.